what you'll want to do is take your yellow packet, go back where you were sitting so you can get your materials. What you want to do is take your yellow packet, pull out the sheet in there that is a green sheet, and at the top it says immigration relief. So pull that out, and then also you'll want to have in your hand or near you the PowerPoint presentation, because you're going to be doing hypos. You'll be paired up. But this is not to test what's floating in your brain, but it's for you to be able to try to identify some issues, but you can do it with the help of all the materials you have. So just make sure you have not the blue sheet, you want the green sheet, and then look around and find someone who looks very smart and have them be your partner, because you're going to pair up with whoever you want. And I'm going to give you about 15 minutes. What you want to do is read the hypos, and there's some questions that follow. And I'll just give you, maybe 15 minutes to talk about them. And then what we'll do is come back, and then we'll discuss the answers. I'll have you give input, and we'll talk about the cases. After that, what we're going to do is spend about a half hour going over the juvenile delinquency issues, and then we'll have a similar breakout session. This is to keep you active in the afternoon. So we'll have a breakout session on delinquency as well. After we finish the delinquency issues, then we'll spend about the last hour talking more about immigration court removal proceedings, working with detained parents and immigrant families, and then talking about the resources. So find your partner, and you've got about your 15 minutes. Try to get through as much as you can. I know, some people only got through one, it's okay. If you were very careful about the one. So you'll have to answer the one, because we know that's the one you did. So what we're going to do now, it's about 1:30. We're going to spend about 15 minutes going over, talking about these examples. And I'm going to take volunteers. And I will not allow the immigration attorneys to be the first volunteers for answering the questions. But maybe we will force them to answer the questions if we don't have other volunteers. So the first one that we're going to talk about is Joshua, and this is the 15-year-old kid from Uganda. So I think these two women up front will say something about him, since they spent their 15 minutes on him. So the question was, what kind of immigration relief might he qualify for now? And do you have some thoughts about challenges he might face if he's trying to get that immigration relief? And one thing for everyone to think about, or just to realize, that I think will become clear, is that a lot of these immigration options are not mutually exclusive. You may run into a lot of cases, honestly, where a person qualifies for nothing, but that makes not a good hypo at all. So these hypos have a lot of facts, but what you realize is that you may run into folks who qualify for a whole range of immigration relief. And so sometimes it'll just be one thing, but often because there are forms of relief that have humanitarian grounds, sometimes people will cross into multiple forms. And that's one thing that'll come up as we discuss it.
If you have somebody who qualifies on multiple grounds, do you do multiple applications, or do you just pick out one that's the best?
So the question is, what do you do if they qualify for 4 things or 3? Do you apply for all of them? Do you apply for one? What I tend to do is, if it's an affirmative case, so the person's not in removal proceedings, I'll usually evaluate the case. I'll pick the one that either is the strongest or has the most potential benefit, whether it's public benefits or benefiting other family members, and I'll pursue that one. But I will have the others as backups in case there's a problem with one. So sometimes I'll have a case where it's an SIJS case. I think it's going to be a good case. I file for SIJS. If there's some concern that maybe the Immigration Service in its discretion would deny the adjustment because the client has a long delinquency record, I would then say, okay, I could file for a U visa. I may hold off on doing that to see what happens with the SIJS. If the child gets put into immigration court proceedings, then I would pursue whatever I could with the SIJS. I would pursue the U visa. I would pursue asylum. It's usually in immigration court that it's my feeling is it can be like you throw everything against the wall and see what sticks. You don't obviously want to be filing frivolous claims, but that's the place where you probably are more likely to be doing things simultaneously. I think it's a little bit cleaner to pursue one at a time, but you're not prevented from doing that. They generally are not mutually exclusive. The time when you wouldn't want to do something like that is if, say, because you want to keep in mind that the child's going to have an A file. So the Immigration Service is supposed to be adjudicating everything with and in that file. So if you have an SIJS case where you're filing based on substantiated abuse by the mother and it's not approved, and you simultaneously or later filed a U visa claiming the mother never abused the child and trying to immigrate the mother, you just may create some messy situations because everything should be viewed together. So my general approach is to do them one at a time. But again, if the child's in removal proceedings, usually that's a time when you want to be doing everything you can do because you're attempting to avoid the ultimate, removal.
Does Immigration Services ever help you out and they say, you know what, you filed this as this type of visa, but this kid isn't going to qualify, but based on that situation here, you might want to try this type of an application?
So the question is whether the Immigration Service is helpful to us in any way in identifying relief. And I haven't had that happen where I've filed for one thing, they've suggested another. But certainly I think has been known to happen. I think that there have been some asylum offices that are adjudicating children's asylum claims who realize, this child actually should qualify for SIJS. They have a guardian. I don't think I'm going to approve their asylum claim because it's a really difficult case, but it seems to me like this is a case you should assess for SIJS. Or they may say, the child revealed they were the victim of a crime, maybe you want to do a U visa. So it certainly happens. I wouldn't say it's frequent. I think it theoretically would be more likely to happen in immigration court because the judge is supposed to be eliciting information to identify forms of relief. But the reality is that a lot of immigration judges don't know much about SIJS and they may not know that much about the U visa. So even though theoretically you could get some assistance there, it's not always the case. But we have done some training on SIJS it's not really formal training, it's sort of training by doing the cases where now we have about 25 or 20, maybe almost 30 immigration judges in LA now. And the ones who have become familiar with SIJS through our cases now will actually refer people to our office because they think the child qualifies for this relief. And that's been less through directives from the higher ups of immigration court and more because they see that this is actually a really great form of relief and that it gets the kids off of their docket and gets the kids green cards. So that can certainly happen. But I think CS is not really obligated to be helpful in that way in identifying alternative forms of relief. All right, you're on. Anything you have to say about him? He has a lot of things going on, so anything you want to talk about.
I guess we had pondered asylum, whether he could.
Do you want to turn around a little? I'll repeat it, but so people can hear.
No.
No. Okay, never mind. I'll repeat it. I'll modify and repeat it so it's all correct. Go ahead.
Modify it to be correct.
Okay.
I'll just say whatever.
Right.
I guess we had pondered asylum, but I guess we weren't sure what the long-term benefits were for asylum versus we had also looked at the T visa.
Okay.
Under the trafficking in persons through fraud. Obviously it wasn't for sex, but it would be for the labor, I suppose.
Okay. So the one thing they mentioned was the asylum claim. And so you see this case and you think there is potential for this child to have an asylum claim. He was part of the Lord's Resistance Army, but he also had threats against his life by the government. So you could or you would want to analyze whether he would have a well-founded fear of future persecution upon return to Uganda because of either an imputed or real political opinion or his membership in a social group of former child soldiers. So that's certainly something that you would want to look at. I think that in a case like this where he's not in removal, that again, the chances of prevailing may not be that high. So it probably wouldn't be the first form of relief you would want to file for, but you would want to think about it. One thing that complicates his case a little is that people who have persecuted others are not eligible for asylum. So whenever you see someone, even if they were a child soldier, engaged in combat, and depending upon the nature of the combat, you may actually run across a situation where you have a persecutor on your hands. There are good legal arguments why child soldiers shouldn't fall in that category, but it is somewhat untested. So it's just something to be aware of. And with adult cases as well, you may see people who were in the military in their home countries and perhaps involved in some sort of horrendous acts in their home countries. So they may not be pursuing asylum because even though they do have a well-founded fear, they also have their own persecutory history that may bar. The other option was, another thing they thought of was a T visa. And so that would be triggered by he was brought here, he was forced to work, he was kept there. And so you would want someone to assess the T visa possibility for him, for sure. I think when you see a T, you also would think, is there a U? Because unfortunately, often these things go hand in hand. And the US Department of Labor, were it involved in some raid on this workplace, has recently, I think last week, said that they would certify U visas for cases of involuntary servitude, peonage, obstruction of justice, or witness tampering. So there is potentially an option for a U visa for him as well. So a T and a U would be something that you would look at. Do other people, did anyone come up with anything else that they thought should be at least considered for him, regardless of how they thought it would end up? Yeah.
Well, they don't say anything about the parents, so I wanted to know if one of the dad was a citizen at the time of birth or anything like that.
Exactly. So one of the things that's not here, and the hypos usually, they almost all include things like things you need to know, but we don't know yet, or we haven't told you. And so in here, you would want to know the father is here, he's been located. Is he a citizen? Is the mother a citizen? Where is she? Is there any way that this child may actually be a U.S. citizen, even if no one seems to know it yet? So you would want to know that. If the father perhaps recently became a citizen, is there some option for family-based immigration? Where is the mother? What's her status? Could she immigrate the child? So there are different issues that can come up that are about the parents that we just didn't, I didn't include here. Did anyone have, go ahead.
I just had a question on the T visa. If he came here and then was brought into kind of the slavery situation, is that different than if he was brought here with promises of?
I think that people have been successful on Ts if they're brought into the country for purposes, and then directly enter the trafficking. But I do think there have been T approvals, I don't know if you've handled one, where the person falls into this trafficking situation here. And there's some requirement that they need to be in the US on account of trafficking, but I don't know that that's interpreted to mean the actual physical entry had to be directly tied to the trafficking. So you could see potentially some parents who are here may end up with T cases. I know we've seen a fair number of people who come in as people who are working for foreign diplomats and then end up having their passports taken away and they work 24 hours a day. So many of them are cases where people are brought in specifically for these kind of purposes. And unfortunately, for sex trafficking with children, it's a really unfortunate situation that we see where that tends to happen a fair amount. But I think, again, they often are not cases that come to light. Any other options for him? Go ahead. Open juvenile case. Okay, so there is the possibility for SIJS for him. And again, I think there's some unknowns here because we have him taken into protective custody, but it's not clear what's going to happen on that open juvenile case. Is the court actually going to place him in the custody of an agency or some other individual? Or is the case just simply going to be closed out somehow? So SIJS would always be something to be considering because you have the juvenile court involvement, but I think the question would really be how is the case going to proceed, and that would be somewhat determinative of his options for release. It actually used to be this hypo, the answer was no SIJS, because if the idea was that he was returning to his father, he couldn't be eligible because you had to show reunification with neither parent. But now that the law has changed, the hypo has changed, the answer to the hypo has changed a bit, which is that SIJS, depending on the mother's situation and what happens in the juvenile case, may continue to be an option for him. Go ahead.
They still have to show collective use for him.
Exactly. And that's why we would want to know, is the mother deceased? Was she in Uganda and was abusive to him, and that's why he joined the Lord's Resistance Army? We'd have to have a little more info, but you would want to show abuse, abandonment, neglect, at least as to one parent. If it turned out the father's here but refuses to take the child back and he stays in a foster family, maybe you have one of those things as to the father who's here. But either way, you need it at least for one of the parents. Anything else?
You would like the case to stay open?
So you would like the case to stay open. I mean, this is the thing. You would like the case to stay open if the case needs to stay open. I mean, if he has other options, like say he has a U option, and maybe being in juvenile court isn't the best thing for him, then someone can pursue a U no matter what happens with the juvenile court case. If SIJS is his only option, he wants to pursue that, everyone's on board with that, you would want the case to stay open. But SIJS is really the only one that has the juvenile court, open case requirement. So all the other kinds of relief are things that he could do even if the juvenile court case got closed tomorrow. All right, so the next person, you guys are off the hook, thank you, because you did the first one for 15 minutes. The second one, Sarah, who was born in Guatemala. Who wants to talk about this? This is the one, what immigration relief might she have been eligible for in 2007? What could she do now? And then sort of separately, if her mom reappeared and wanted to help her, what are some of the problems that she might have? So the 2007 question is, her case closed in 2008. Good, we have like a great volunteer. So juvenile case, again, She was in 2007. She still had her case open. I think that the question you would probably have, and I think there's nothing in here about her father, it says family reunifications were terminated overall. So she should have been eligible for SIJS back in 2007. And if she had gotten it then, she'd actually be about a year away from being able to naturalize. But it didn't happen then. And unfortunately now her juvenile court case is closed, so there would be some issues. You couldn't apply for SIJS now, number one, because her case is closed, but number two, because she's 22. So say that she had come to you and she was only 20. If there's any mechanism under Nebraska law to reopen her juvenile case, if she's 20, and there may not be, I don't know, but if there were some mechanism to she comes to you, she's 20, and everyone realizes, ooh, we should have done this earlier. As long as there would be a mechanism to reopen the case, even to get a nunc-pro-tunc sigis order, as long as she's under 21 and she meets the requirements, and there would be an open juvenile case as of the date of the filing, she could still pursue SIJS. I made her 22 to make that impossible, but the reality is that if on the state court side you could pull that off, then you could do it on the immigration side. And the Immigration Service does, just so you know, has recognized nunc-pro-tunc orders for adoptions. And I haven't done one with an SIJS case, but I suspect they would recognize them as well. So if she were a bit younger, SIJS might be on the table. But for her now, she's out of luck on that one. So do people have ideas? She's in your office. This is a sad day for the SIJS. But any ideas for things she might qualify for now? U visa. So her response is U visa, she's a victim of drive-by shooting, that would be the clear way. And that is this is based on a case that we had of a child who was a victim of drive-by shooting. And that's exactly what happened. To be able to show the harm was incredibly easy. In this scenario, she testified and helped the perpetrator to go to prison. And so I think this would probably be a slam dunk U visa case. And it would actually, I think here we didn't have a time limit. Even if this shooting had occurred when she was 15, as long as someone would be willing to certify the U visa, you could apply for it now. And so whether the shooting was recent or whether the shooting was actually years ago, as long as you could get a certification and meet the other requirements, you could apply for the U visa now for her. So unfortunately, the drive-by shooting has sort of helped her in this one way. Did anybody else have any other ideas on the immigration relief? And you can also talk about anything she might be able to do with her mom. That was the follow-up question. Is there anything if her mom shows up that her mom might be able to do to help?
Would she be able to apply for the family-based immigration if her mom came back and helped her? But she'd have to leave the country first, wouldn't she?
Exactly. She would have to leave the country at some point. The response was maybe the mom could help her with the family-based immigration. So the important fact there is you have a mother who's a permanent resident, there's a parent-child relationship. The problem or the challenge that this child may have, or now young adult, is that because her mom's a permanent resident, the wait time for her to have a visa number available to adjust is going to be very long. And then because she entered the country, we said, without permission, she has the additional hurdle of, I'm doing family-based immigration, but I came here without permission, unless she falls into a pretty narrow exception for people who had long ago previously filed immigration applications. She would be required to leave the country and then come back, very likely would be barred for 3 or 10 years from coming back. So this is a clear case, I think, where a U visa is great because it doesn't have any of those problems. That whole process can happen here in the US. But the family-based, if there was no U visa eligibility, someone would want to consider that for her. I think it would just be ultimately a difficult thing. She's born in Guatemala. One other potential kind of immigration relief, if she were in removal proceedings, would be an asylum claim. But because she came here and has blown the 1-year deadline by many, many, many years, my advice to her would be not to apply for asylum now, but were she to find herself in removal proceedings, she might be able to seek asylum or withholding of removal there. The withholding does not have the 1-year deadline, but there's very good, I would tell her to move to the Ninth Circuit and then file for asylum because there's a very good recent decision about asylum claims for women as a particular social group in Guatemala without any other qualifiers. So it's actually an incredibly helpful decision that potentially would cover someone like her. She still has the 1-year deadline problem regardless. But that's why the asylum, you would think of it, but it probably is not something that you would want to pursue too far. And then Henry, we have Henry, the 14-year-old. He came to the US from Mexico on a border crossing card. And that's the card I showed you earlier that said it was valid for 10 years. It was a B visa card. So he's been here ever since, physically abused by a lawful permanent resident father for years. What do people think about what kind of immigration relief he might qualify for now? What kind might he qualify for in the future? What are his options? And you can also factor in his mother's options also if you want to, or at least think about those when you think about what he could do. So one possibility would be VAWA, and so you would want to look and see, is the father's a permanent resident? Is there any chance the father lost his residency because he was convicted of some crime for this abuse? You would want to figure out what the current status is, but presuming he's a lawful permanent resident, there may be the possibility of pursuing the VAWA relief for the child. If the mother was abused, the mother also possibly, and was married to the abuser, she also may be able to do VAWA and to include the child on her application. Again, if the father was a permanent resident, then if they pursue VAWA, the ability to get the green card may be further down the road because they're going to be treated a bit like the family-based immigration in that they can't ultimately get the residency card until they have a visa number. The benefit for them was they would at least have a work permit in the process, which is better than the family-based immigration options. Did you have a question?
I was just, if somebody's found eligible through VAWA, then like in this situation, is there ever a time where then they would go after the father for, like if he hadn't been found, would they try to deport him then because of that stuff?
So the question is, what risk do you run if you file for VAWA or even for a U visa and the perpetrator has lawful status but isn't a citizen? Will the Immigration Service or somebody go after the father? I think that we haven't had that happen in any of our cases, but we also tell people who are concerned that it's always a possibility that the government could do that, because particularly if you're producing conviction records showing my father was convicted in criminal court for child abuse and drug trafficking and a million other things, then you might, arguably the government now has its hands on evidence that would establish the deportability of the father. And so certainly there have been cases where people are concerned about that, and we can't ever promise, because as far as I know, there's no provision in the federal law that says there's a firewall between these kind of cases. But I haven't seen them actually do it. You can imagine a situation where they would, if the facts were incredibly extreme. I could see that happening. And sometimes there are very complicated family dynamics where, despite the abuse, they don't want to put the father in that situation, and that's just something that, the family will have to figure out what to do.
In a situation like that, it's generally when they leave the country and then try to come back.
And so,
In
right, it's often that people, if they're traveling outside the country and coming back, like we said before, it's a port, whether it's the airport or a border port, where the Immigration Service can take another look at your case and allowing you back in. And so some of the things, whether they're convictions or other issues, abandoning residence, may come up if the person travels abroad, regardless of our application or not. So that's then the VAWA. Any other options you can think of for him? So the U visa also, so he was physically abused by the father. Say that his mother wasn't abused, but he was. The benefit of the U potentially would be that he could benefit the mother if he wanted to do that. The U visa issue that may be a little bit problematic initially was that, not problematic, but the reality would be the mother didn't call the police, so there was no police investigation, there was no restraining order, there was nothing you could do on the police side. So you would either be in a situation where you would want the crime reported formally to the police for investigation and get a cert that way, or if the facts lined up in a way that Child Protective Services was involved and actually investigated that underlying abuse, you might be able to get a certification from HHS or Child Welfare. But again, the thing that you want to remember on these kind of cases is that if this child came to my office and there had been no juvenile court involvement and no police report done, then we'd have a sort of tricky a situation in our hands, because there's clearly the abuse and the crime, but there's no cooperation with law enforcement because law enforcement was never notified about the crime. And so certainly, there are cases where people go and report crimes after the fact. But generally, that's one of the things we look out for on the U visa, is really to see, is there a potential certifier that already exists? Because while there's nothing to prevent someone from reporting the crime to ultimately get the U visa certification, it may make the certification process harder because the certifier may be concerned that either the abuse was fabricated or that their only motivation for doing any of this is that they want to get an immigrant visa. And sometimes that is not something that law enforcement is interested in getting involved with. So that would just be an issue that would definitely need to be investigated. Anything else anybody thought about?
Juvenile court.
open juvenile court case. And so I think the question is here, he's got an open juvenile case, so would he be eligible for SIJS? And the thing we want to think about here is there going to be reunification with one or both parents? If the mother is still living with the abusive father and for some reason it turns out that the child's going to be reunified with both, or that their reunification services are being provided to both, then you couldn't seek SIJS initially for that child because you wouldn't be able to meet that no reunification with one or both parents. But if the case remains open and the child's reunified with the mother, father is out of the picture, then SIJS may be an option. This might be a case, though, where you would want to pursue a U, because if you do the SIJS for the child, the mother will get no benefit. If the child wants to benefit the mother and is able to, that's why thinking about a U visa, if there was a report, would be helpful, because you could address parent and if there are any other siblings as well. The only other potential option here is the family-based immigration period, because you do have a lawful permanent resident father, you have the father-son relationship, but this is kind of an example of why VAWA is an important kind of relief, because trying to go forward on a case where you are representing a father and a son on an immigration petition where you know that the father has been abusive to the son, it can be very complicated and also tie the son to the father more than perhaps they want to be tied at this point through the legal immigration process. So certainly to the extent that VAWA is an option would probably be preferable. It would give the child additional benefits, but it would also kind of cut the father who is abusive out of that picture. So I think that's everything for, asylum for him. I would say probably not. If he found himself in removal proceedings, then certainly he could assert that claim, but in terms of someone affirmatively going forward, that probably would not be a great option. Go ahead.
Just out of curiosity, if you're a 14-year-old kid and say you're an immigration lawyer, how do you approach a U visa for a 14-year-old and say, what do you want to do?
It's really difficult, honestly, to do that, because usually the kids that I'm working with are kids who don't have parents in the picture, who would otherwise, if it was a parent-child coming in for immigration relief, you'd usually be looking to the parent for guidance on the decisions for the child's case. Often the cases that I have, if there's a guardian, I have very frank, direct conversations directly with the child in all the cases that I have, unless they're so young that they don't understand like what a country is and what a border is, and some of those conversations don't really work. But I think that to the extent that there's a parent or a guardian or an agency that's legally responsible for the child, some of those conversations and decisions could be made with those people. But at the end of the day, the child is the one who ultimately bears the burden of all of these decisions and has to actively participate in most of the cases. And so I actually think 14, 15, 16 is an easier time to have those kind of conversations than for younger children. But it's interesting because I think that most of the clients that I have, most of them often don't have multiple options, so the conversation's a little bit easier. There's this one thing we could do, or there's nothing that we can do. And so I think for them that decision or wrapping their mind around that is a bit easier than situations where they're competing forms of relief. But it is interesting, I think, how frequently children have very clear opinions about what they want to do or who they do or don't want to benefit if they could through their cases. And ultimately, if I'm, representing the child, I can be concerned about the mother or the siblings, but if I'm not representing the whole family, then the focus is really going to be on the child's immigration case. But I have found it to be somewhat infrequent that the child has no opinions or any sort of inclination about what way they want to go in terms of immigration relief. But again, this is why I think for people who don't work with kids a lot on the immigration side, it's very challenging as an immigration lawyer to be used to be representing adults and then have to come into a case with a child and not have the vocabulary or necessarily some of the sensitivity to how to work with children. And I think that you want that in an immigration lawyer, hopefully, for any of these cases, because it can be very complicated issues.
One of the alternatives would necessitate mother leaving the abusive father, which complicates the matter dramatically, considering the fact that the last statistics I saw was mother leaves father marriage 23 times before she ever
Right.
actually stays
Yeah.
away. So, and as a juvenile judge, I think it's almost 50-50 that I've seen where mother's willing to stay with the father and give up the kid.
Right, right. And so some of these things, you know, if that is the decision, the juvenile court makes their decision, we're not going to reunify with the child with the family because the mother is not capable or hasn't been able to leave the father, then that is going to open up SIJS as an avenue. It doesn't close the U visa potentially if you wanted to go that route. But the reality is that if the mother has been abused by the father, probably the easiest thing would be for the mother to have her own immigration attorney to pursue a U visa for her independent of the child. And then either you could do SIJS for the child, or if you're going to do a U visa for the child, you could link the cases. But sometimes the best thing to do for cases where parents are also undocumented or have immigration issues is to try to link up the parents with a different legal services provider to assess the parent's claim. And the mother may have a U visa claim even if she stays with the abusive husband, you know, till the end of their days. She couldn't benefit him through the process, but she could get the U visa on her own. And then the child would be free to do either or any of the forms of immigration relief that are available to him. All right, so that is our discussion of the hypotheticals for immigration relief.